Good morning and welcome to MBBA Learns webinar, Will You or Won't You? A discussion on pop culture, celebrity deaths, and the ramification of not estate planning. I am Paula Edgar, and I'll be introducing myself in just a moment, but I bring you greetings on behalf of President Jason Clark, who is unable to join us today, but he is our current president. And the theme for the Metropolitan Black Bar Association this year is Community First. And so there'll be lots of initiatives surrounding the community and interaction with the community. I want to do a quick check to make sure all of you can hear me. So if you can hear me, if you would use the dashboard, raise your hand. I can see. Great, thank you. All right, so at least two of you can hear us. And then that's a great time for me to remind you that when it's time for us to have questions and answers at the end, you'll be submitting your questions via the webinar dashboard, and that will prompt me to ask the panelists and myself any of your questions. Okay. All right, just a moment. So, the Metropolitan Black Bar Association was established in 1984, and it's New York State's largest black bar association and also the largest affiliate of the National Bar Association, which is this is odd. Apologies, I'm understanding that you can't see the slides moving. So just a minute, I'm going to fix this so that hopefully this, all right. Can you all who are the panelists let me know that worked, what I just did? Can I get a hands up if you can see the slides moving or anything so I can just know? That's weird. I'm not sure why that's happening. It's still frozen. All right. Apologies for the technical difficulties. It's moving here, but it's not moving for you, so I'm going to stop the sharing and I'll restart it. Okay. Let's see if that works. Okay. Let me know if you can see the slides moving now, please. Okay, great. Thank you. All right, sorry about that. And thanks for letting me know. Okay, so there we are. Sorry, there's Jason. And here's the theme for this year. And then again, about the Metropolitan Black Bar, we are the largest affiliate of the National Bar Association, and we do encourage you to join us. If you visit mbbanyc.org, you'll be able to join or renew your membership and also see any of our upcoming programming and initiatives that we have on our website. So we look forward to you joining us and engaging with us throughout the year. All right. So we're going to get started with the webinar, and I'm going to ask our panelists to introduce themselves. Anta, would you go ahead and introduce yourself, please?
Yes, good morning. I am Anta Cisse-Green. I'm currently the MBBA president-elect, and I am an associate general counsel at NYU Langone Health, where I have been for 2 years now, and previously I was at large law firms practicing trust and estates for individual clients.
Thank you. Carl?
Good morning, everyone. My name is Carl Forbes, Jr. I'm the principal of Carl Forbes, Jr. Law Firm, a general service boutique law firm designed to meet your everyday needs, where, among other things, I focus on trust and estates work.
Wonderful. My name is Paula Edgar, and I am the immediate past president of the Metropolitan Black Bar Association, and I'm a partner in my own consulting firm. It's a diversity consulting firm called Inclusion Strategy Solutions, where we provide diversity consulting, diversity training, and other training and professional development needs for a myriad of organizations, including law firms and other nonprofits. So Looking forward to getting started. What we're going to do first is we're going to launch a poll. So using your screen, you can see this now in just a moment. Answer the question that's on the screen. So we're asking, do you have a will or any other estate plan documents? And with 67% of folks who are on the line having voted, I'm going to close in just a moment. So if you haven't voted yet, please do vote. Okay, so where are we? All right. I'm going to close, and I'll share the results. So you should see that, yay, 75% of folks who are on the line do have some sort of planning document regarding estate planning, and then 25 of us, because I will join within that, but that will be resolved shortly, don't yet. And actually, I should be under the what had happened was. Okay, so thanks so much for participating in that. And we're going to go ahead and get started with the content. So, what is wrong with this picture? Like with these pictures. So we have Aretha Franklin, Bob Marley, Prince, Sam Cooke, Martin Luther King Jr., Jimi Hendrix, Steve McNair, Tupac Shakur, and Marvin Gaye. So you might imagine, given the topic that we have, we're talking about pop culture and folks who do not have a will, that yes, you guessed it. Some of them have wills, but they fail to plan sufficiently for their deaths. And so starting the conversation, it should be said that, there's obviously a lot of reasons, a myriad of reasons why people may not have focused on their estate planning. Obviously none of us want to think about not being here, but if we truly do love the people who we're leaving behind, it is imperative that we plan for us being gone, because when you don't, the confusion, the stress, and all of the other things that go without having an estate plan in place definitely comes into play. And I can speak from experience, having had my mother pass away without a signed estate plan. So, Anta, will you talk about, do you have a will or estate plan in New York? What's going to say?
Yes. So I'm glad to see that we actually exceed the general statistics. But you will see, so AARP in January 2017 did a survey to find out how many people actually have estate plans in place. And as you can imagine, the people 72 and older, 81% had estate planning documents, which is normal because as you get older, we really start to reconsider our mortality. 58% of the baby boomers had something, but where we fail is, the Generation Xers and obviously the millennials, right? Because for some reason or another, we don't think of it, we don't want to do it, it is forbidden, it's not part of our faith. So there is, a huge lag of individuals who fail to plan between ages 18 and 37. Next slide. Power of attorney. So we will cover the purpose of a power of attorney a little bit later in this webinar, but at a minimum, that's one of the documents that I would recommend people really take a look at and implement as soon as possible. Everyone 18 and older should have a power of attorney. And again, people between 18 and 36, 41% do not have a power of attorney. And it's important to have this sort of document because it helps you during your life, right? Because the power of attorney terminates once you die, but having a power of attorney can serve a number of purposes. Next slide. And then finally, just generally, right, they asked people, what is the reason that you do not have an estate plan, right? And I think the first one is sort of hadn't gotten around to it, right? That's what happened was 47%. Either you had good intentions, you've talked about it, or somehow, you just didn't get to it. And then 29% thought they didn't have enough assets to leave it to anyone, so what's the point? Right, so that gives us a total of 76%. The question is, what happened to the others, right? And my guess, honestly, is that, either they don't know, right, that they could have an estate plan, or they don't even understand where they should begin. And that's a very, very important point. Next slide. So the question is, what exactly is estate planning, right? Because if you don't know what it is, you obviously will not be able to create or implement one. And it really is as easy as just taking control. So estate planning is the process of figuring out what you want to happen to your estate now while you are alive in the long term and after your death, and then taking the steps to make sure your wishes are carried out. And then if you have sufficient assets, you also want to take into consideration the most tax efficient way to be able to implement your estate plan. Next slide. So as I said, estate planning is about control, right? Yes, we may not want to think about our mortality. Nothing's going to happen to us right now. We are supermen, superwomen, but it's about taking control. And some people may say, I don't really care what happens when I die. And that is completely fine. But I think the problem is that we do not understand what happens when we die. People are absolutely lovely. Family is getting along great. But as soon as you pass, that is when everything completely collapses. Right? So what we need to do is we need to prepare the proper documents: will, power of attorney, living will, healthcare proxy. And then we also need to review what we have in place right now. So most people think estate planning or a will or a trust, or some of the ancillary documents, but they tend to forget that if you have a life insurance policy, any sort of retirement plan, 401k, pension, or any other benefits, right, you need to make sure that you take a look at those also to make sure that they actually reflect what you want. Because especially if you started a job, you've been there for 5, 6, 7 years, you signed up initially, and maybe you're really good about allocating, the assets, the securities for your 401k plan, but you never go back to look at your beneficiary designations. All right, and that's really important when we're talking about implementing a plan for you for the future. Next slide. So why do you need a will? Again, it comes down to control and decision making. You have been taking care of yourself, your property, your assets during your lifetime, right? You make all of the decisions for yourself. So why leave the decision up to someone else when you pass, right? You need to be able to take control of everything in your life now and also after you die. And I think that is one of the key things that people don't really take into consideration, right? They say, I don't care what happens after I die, my family will figure it out. Well, a lot of issues can, come to play once you die, and your family's not going to be able to figure it out. And some do. I will, give that to, there are some individuals who are great at doing these types of things. But when it comes to control and decision making, you want to make sure you identify the individuals or the entities that are going to receive your property. You want to identify the individuals that you trust, that will take care of your property and also, fulfill your wishes, right? Because the person that is going to act as your executor, the one who administers your estate and distributes your property, that individual needs to be trustworthy. They need to be reliable. They need to be honest, have some integrity, and they also need to be able to fulfill your wishes down to the last description. Next slide.
Anta, before we move to the next slide, I'd just like to add a point to the control and decision making there. Part of why we chose that image of the private property, no trespassing sign. I like to think of creating a plan as similar to putting up a fence around your home or having doors and locks on your home. As you're living, you get to decide who comes and goes in your residence, and thinking about your estate plan, you get to decide who inherits, who's responsible for handling your final affairs, who gets to work with your family in order to put everything together based on the wishes that you have written down. And if you don't create a plan, basically at your death, you're opening the floodgates to any and everything taking place and all hell potentially breaking loose, as you previously mentioned.
Okay, so why you need a will? Let's look at control and decision making. So we have our first celebrity call out, and this is Bob Marley, who died on May 11, 1981, which I think I'm supposed to know that by heart as a Jamaican, but anyway. He left a wife and 11 children, 3 children by his wife and 8 by other women. We'll pause on that one. Am I supposed to go through all of this? I just want to make sure you want me to. Carl, am I going through all of this?
As you feel free.
Yeah,
okay,
as you feel free, Paula.
Okay. Sure, sure. So he was of the Rastafarian faith, so that faith does not permit estate planning. As you see there in bold, he had no will. His estate was valued at $30 million at the time of his death, and I'm sure probably more than that now, which is to the point of what happens after you're gone. So Jamaican law applies here. So the wife automatically gets 10% outright and 45% of the life estate, and the children get 45% outright and the remainder of the wife's life estate. And so I guess I need a little call-out clarification here. So is this the children of the marriage, or is this the children, period? Do we know?
It's the children, period.
Okay, interesting. And then so his image and likeness, which we were just having a brief conversation before about this as it applies in the United States, the wife sued the estate for control of his image and likeness and won?
Mm-hmm. Of course, it took years, but eventually she won. And so what we mean in this regard is, what we were just talking about is it really does depend on what state you die in, what country you die in. Because think about if someone takes your picture and then slaps it on a T-shirt and starts selling it, right? And they're making tons of money, and somehow you come across it. You would be very, very offended, and, you would want a share in the profits, or you would want them to stop doing it, period. Now, depending on where you actually die, right, you have that right when you are alive. But once you die, that right may be extinguished, right, which means, it doesn't matter if you are a celebrity or just a regular Joe Schmo. Once you die in New York, for example, right, that right of publicity, which is what it's called, extinguishes. You are no longer alive, so you no longer have that right in New York. Now, California is completely different. California, that right lasts forever, right? So it's very important, especially, if you are out there, you are a public figure, to be able to understand what this means. Because think about, his wife in this case, right, once he died, there's additional profits and royalties that she would be able to gain just from selling his likeness or, licensing it to other individuals, corporations, entities. And that's additional income that her and her children can live off of, right? Her children, and, I don't know the situation with the other non-marital children, but they could potentially also be able to, gain from it. So that's one of the things that why I think it's just really important for anyone who is, a public figure to really think very closely about what their plan's going to be.
And a good example of the timing that it takes on a litigation or a fight regarding image and likeness is Jimi Hendrix, who we mentioned previously. So he died in 1970 without a will. In 2009, 39 years later, his siblings were in court fighting over the rights to his iconic image. Now, I'm sure none of us want to die and think that our family almost 40 years later are still fighting over things related to us because we didn't plan properly or didn't have a will.
No, and that's sobering. That's a lot of years and a lot of stress that I'm sure that okay, I'm hoping you guys can see these pop-ups, but I bet you can. Anyway, a lot of strife and stress going through that kind of litigation for years and years after your loved one is gone. And I mean, we could have filled this PowerPoint with a lot more. There's a lot of people who die and leave things in in limbo. I'm thinking of Sherman Helmsley. There's a lot of folks who we could have included in this, but we would be doing hours and hours of this. So maybe we'll have to do a round two of this. So just to
It feels
complete
like it already.
to complete this slide, so the bandmates, the Whalers sued for royalties, and corporate administrators also sued the accountants and lawyers for diverting assets and royalties into their own accounts. So we had some fraud there, it looks like. But again, when you don't have the T's crossed and the I's dotted, there's much more availability of these things occurring. So we do have a couple questions, and I just wanted to see if I can ask them to you now before we move on, or do you want to wait?
That's fine.
Yeah, I'm fine. That's fine. Taking them now.
Okay, hold on just a second. I just lost the window where the questions are. Okay, sorry. Okay, here they are. All right. So the first question is, what about POLST? Since more people have dementia, I'm not sure what that is. So that's the first question, and the second question is, hold on. Not scrolling up. Oh, there it is. Okay, and then the other question is, what about joint property owned between family members as a first step for people who have done nothing in terms of estate planning? It's an easy way to think of, okay, the window just closed. It's an easy way to think of who the person would be to step in if the property is in joint tenancy with right of survivorship. So a comment, I guess, as opposed to a question. But the first question, are you familiar with POLST? I don't know what that is.
Yes. So there's a number of things. So some people, there's a POLST is physician orders for life-sustaining treatment, and then you also have MOLST, which are medical orders for life-sustaining treatment. Basically, they are documents for patients who are seriously ill and have a life expectancy of less than 1 year. And I agree, for those who are terminally ill, these documents are also very, very important, and they're part of, they are part of the complete estate plan. And they can be, very helpful, especially coupled with a living will and also with the healthcare proxy, right? Because a lot of times, we wait too long to put these documents in place, and then individuals do not know how to proceed with your medical treatment, right? So when you have a MOLST or a POLST in place along with your other ancillary medical documents, it really does make your treatment a lot easier, and it really is, reduces the stress for family and other close individuals to, figure out what the plan is going to be and how to make you comfortable, right? Because everyone is not the same. Some people will just say, leave me at home. I do not want anything. I don't want anyone to interfere. But other people may, want extreme measures to be taken, experimental surgeries or medication. And that's why all of these documents coupled together really are important, especially for the terminally ill. And there are also additional techniques and estate, more complicated estate planning tools that can be used for terminally ill individuals. And that alone is, that could be like a couple of days, CLE webinar. But I'm happy to answer questions afterwards for anyone who has further questions.
We will
I'll briefly address the second question point. A joint ownership, such as a joint tenancy with right of survivorship, definitely can be an avenue that you pursue, but the reality there is you may not want to put all of your property in joint ownership for someone. Take, for example, you have a bank account that you have joint tenancy with right of survivorship. That person has the ability to clean out that bank account. Or, for instance, if you want to transfer the deed to your home to a family member with you as a joint tenant with right of survivorship, if you have a mortgage, the bank may want that person to also be responsible for the mortgage or a car note. And that person might not be willing to take the chance that you default and they're then on the hook as a co-owner or guarantor. And so it's something to consider, but not necessarily a replacement for a good plan. It works sort of part and parcel in ownership of your assets.
Right. And I do want to add something to that, because I've unfortunately had a number of clients who, hold joint property with other individuals, one or more individuals, and especially in the context of a marriage. You have title in property, with your wife or your husband, and, sometimes, and I have had 2 clients where this happened, you get divorced and then you never take another look. Or even worse, you separate and you don't talk to that spouse for maybe even decades and you don't even know where they are, right? And you tend to forget how you actually held this property. And unfortunately, what ends up happening is, we die without a will. People don't, know what to do. They don't petition to be administrator. They don't manage your assets. They just take care of the things that they know about, empty your house or your apartment, and then call it a day. And then someone else dies, and the property just keeps passing generation after generation after generation. And then you end up with 30 people who are entitled to this property. You can't tap into the equity. You can't sell it. You can't mortgage it, and you can't do anything. And unfortunately, that is the position that a lot of African Americans are in. Think about how many people know someone who has property somewhere down south, right? Or somewhere back in, their home country. We're not able to access those assets, and then we're not able to build the wealth the way that we potentially can because we don't take the steps necessary to pass that property down.
Okay.
Right. So
hold on one second, Carl. So I'm going to remind everyone that you can ask questions using the webinar tab, and I see there's a couple left, or one more at least in there. And so we're going to hold up on any additional questions so we can get to the content until the end, but I do see you. Go ahead, Carl.
So this slide is perfect, actually, in response to these last points about, okay, you're wondering if joint tenancy and co-ownership makes sense. That's essentially what you need to do, is take control and sit down and figure out what makes the most sense based on your circumstances. You may ultimately, in conversation with an attorney as well as with your family and determining your wants, wishes, and needs, you may determine that, a living trust makes the most sense. And so I'm going to create a trust in benefit for my family and transfer the home into the trust, or transfer all of my property, my car and things into the trust. Or I'm going to create a joint tenancy with another family member because that's what makes the most sense for me. But if you don't take control and think about these things and start the decision making, what you're leaving it for is for the law to ultimately determine what happens at the point you die if you haven't put these plans in place. Next slide. So what I think for people who are not celebrities, for instance, one of the biggest reasons that you want to think about planning is if you have children. I think that oftentimes we think, if something happens to me, my parents will take care of my child. Well, your parents may be older and they may not be in a good position, as much as the heart may be willing, the body, the mind, etc., may not be able to care for your children or care for them in the way that you want. So you may think about thinking long and hard about naming a guardian of the person, someone you sit down with and talk to about, one, your instructions for upbringing and whether they'd be willing and able to do so. Now, you see it points out in a guardian of the property, and you're thinking, why wouldn't that be the same person? It certainly could be, but you may determine the person who can give physical and daily care to my child or children may not be that great with money. And so the money that I leave to my children's benefit, I may want someone who's more financially savvy to be responsible for managing the money, investing it, paying it out as needed for their maintenance, their education, their health care, and working together with the person who is the guardian in order to make sure they get a full care if something were to happen to you. Regarding life insurance, a lot of people will name their children as their beneficiary, not realizing that children cannot own property outright. And so someone then has to manage that money until the child and or children reach the age of majority in the state, which in New York is 18. Next slide.
Okay, so we have MJ, Michael Jackson, and this is speaking particularly to the guardian piece. He died on June 25th, 2009. He did have a will. Within his will, he left custody of his 3 children to his mother, Catherine Jackson, with another celebrity, Diana Ross, as her successor in the event that Catherine is unable to serve as the guardian. He left his mother 20% of the estate. however, left nothing for his siblings or other relatives. I'm guessing then that the other 80% was for his children.
Well, there
That's right.
was a reported fight regarding his will because he had named a business partner or manager as executor, and so there were some issues that led to the fight. And as you see or point out on the slide, the third party influences that played into the entire handling of his estate.
Mhm. I remember the drama around this, given the nature of how he died as well, right? So, again, none of us, I think, well, generally, if you're not sick, don't expect this to happen, and you think that you'll have time to remedy anything that's going on. But he again died of painkillers and being over prescribed painkillers by his doctor, similar to Prince, who we'll be talking about shortly as well. So here at the end, his mother temporarily gave up custody to her grandson TJ, who is Tito's son. So this is interesting because this is the want of the person who died is to have the mother be the custodian, but that person can then transfer that custody to someone else because now they have full rights. And then she later resumed custody with the grandson as a permanent co-guardian, which I think here might be a good balance given her age. And because Diana Ross is probably her contemporary as well, as opposed to somebody who is younger and likelihood of being able to parent in the same way.
Right.
Have somebody younger. Other comments about this?
Yeah. And I mean, so one of the big issues here is, it actually took a while for the mother to be, appointed as custodian, even though she was named in the will, because other people actually protested and came forward, saying that Michael meant to change it. He wanted me to have, the kids. And then when it came for her to temporarily give up custody, that's where the third party influences came in. And many people were saying that, people were in her ear. She didn't feel comfortable being with the children because of what people were saying, and she was very, very stressed about it. And they even think that, the grandson being temporarily appointed, that was influenced by other people. And so they weren't happy when he was finally permanently named as, co-guardian with the mother. So, even though Michael had a will in this case, I think this is a really good example of, really failing to plan sufficiently, right? Because think about if you had a brother who had millions and trillions, and even if you didn't get along as well, right, he left nothing for his siblings or any of his other relatives. And yes, granted, he had 3 kids, he wanted to take care of them. But it does not mean that the siblings wouldn't object. And it doesn't matter if the siblings, they had, beaucoup bucks too. They're still going to object. They're still going to feel some type of way, right? As my husband always says. And that's where the issue is, right? You think that, even though you're so close to an individual, they're going to leave you something because, and to some people, it's not about the amount of money. Well, to a lot of people, it is about the amount of money, but sometimes it's just about the principle, right? He left me out of his will. I don't understand. And one thing that I've done, especially in the context of guardianship, is I have always advised my clients to write a separate letter to the people who were being named as guardian to tell them why you chose them, right? Even if you've already had a conversation, why you chose them, and why you chose them over other people, and then give them additional guidance on what it is that you want them to pay attention to with respect to raising your children, right? And this is actually a great segue because, again, not having a will, right, doesn't just mean that you didn't create one, right? It also means that the will you created is somehow invalid, right? And it could be something as simple as you signed in the wrong place because there are some strict formalities about, how you should create your will. It could also mean that maybe you just did a handwritten will, which in most states is not going to be allowed, right? Or it could mean that someone objected to the will, right? They went to court and they petitioned and asked the court that that will not be admitted to probate, right? Not be recognized as valid because someone influenced you to change the will, someone influenced you, to put them in the will, or maybe you didn't have capacity, at the time that you created the will. So there are a number of circumstances that could put you back in the position where you do not have a will, right? And so what does that mean? People won't be happy, right? And you won't be happy, probably turning in your grave when you see some of the things that happen, right? And again, this can take years, decades. And then the other thing that happens is, the state law will govern. So if you have no will, or if your will is revoked, or someone destroyed it, or you destroyed it, then the state law will govern. And, New York is one of those states that, finally has a statute that says, here is what's going to happen in terms of who will get appointed as your executor, as your administrator, right? So if you do not have a will, we call the person who handles your estate an administrator. The administrator, and there's a priority, right? There's a hierarchy as to who can actually act as your administrator under the law. And then, we also have to talk about, which we'll get into more specifics, who can actually inherit under the law. And again, New York law will govern, or wherever it is that, you or the decedent dies, that's the law that will govern, and they're not all the same. And then finally, the most important thing people always forget is if you don't have a will, if people are fighting over your assets, it could take decades, right? Or if no one comes forward at all, right, the state could end up owning your property. Right now, granted, what the state ends up doing is they will put the property in escrow, and they will wait a very, very long time before they even touch the assets. But eventually, if no one comes forward and the issues aren't resolved, New York State could be a little bit richer because of your property, and we don't want that to happen. Next slide. So again, I do want to emphasize that state law governs, because what people do not understand is the state law will tell you who can inherit from your estate. All right. So if you have nieces and nephews that you are very close to, that you want to take care of, or, you just generally think, what, my siblings are trifling and they're not going to do anything for them, guess what? If you don't have a will, you're not going to be able to do anything for them, because ahead of your nieces and nephews are your spouse, your children, your parents, your siblings, your grandparents. There's a whole lot of people that come before your nieces and nephews. And forget about cousins. Cousins aren't even contemplated. They are, unfortunately, at the bottom of the totem pole. So if you don't have a will, there is no way that cousin Pookie or anyone else is going to get a share of your estate, because they are not contemplated, under New York law or under even other state laws, because there's other people who are entitled, to inherit before them. And then, of course, you have, significant others, stepchildren, siblings, in-laws. And that's one thing people, and I can understand, right? So if you have a daughter-in-law or a son-in-law, and, let's say, God forbid, that your child dies before you do, their spouse is not going to inherit from your estate. They are not entitled, right? Now, yes, your grandchildren would inherit, but that spouse is not going to inherit anything from your estate. It doesn't matter how close they are. They could have been the one by your, deathbed. Under the law, they will inherit nothing at all. Next slide.
So I'm going to take a moment for this one because it's hard for me because so Prince died on April 21st, 2016 without a will, which I think most of us were shocked by that. It unleashed a tumult of lots of folks who were coming and trying to make claims on his estate, including a previously unknown wife, alleged children. I mean, this is a small list. There were people who said they were cousins. It was all ton of folks. We actually found out a lot more about his family structure based on him dying than we knew previously. And so the folks who ended up with taking from the estate was his blood sister and his 5 half siblings. The value of his estate at death was $200 million, and that and then I guess at that point, no value put towards the vault of music that he had previously unreleased, which they are slowly releasing now. So again, not an expectation that there was going to be a death. He was not. I think he was 50-something years old, but this was again a pain-induced, similar to Michael Jackson, that he was taking excess pain medication to deal with injuries that he'd had. So, other thoughts about Prince's estate?
Yeah. So even though, it wasn't even that long ago that the court decided, that the sister and the other half siblings were entitled to the estate, there are other people who had brought litigation, claiming that they were related to him, and they are in the process of appealing, right? So it's not over, right? And it doesn't mean that they're going to win. I mean, who knows? You never know what's going to happen, but it's not over, right? And so in this case, what ends up happening is, the court will, look at the documents, and it really is a high burden for you to be able to prove that you are related to the individual that died, right? We call this kinship hearings. And it's a hearing where you bring forth all the evidence possible to show how you are related to the individual. Now, in this case, I was a little bit confused because, there were some people who claimed that they were siblings, but, other people, claim everything from alleged children. I mean, I don't know. Some people do have gall, and I've had one case that went, the full length of the trial where they tried to bring as many witnesses as possible, claiming that they were the son of the decedent who was a male. And unfortunately, when you're trying to prove that you are the child of a male, it's a lot harder. You're trying to prove that someone is your father. It's a lot harder to prove that than it is to prove that, someone is your mother, for obvious reasons. But it goes back to the rules of family law and, if they acknowledged you, how they acknowledged you, to whom they acknowledged you. And so that's why these cases can go forever. And, I don't think this case is over. Not to say that I don't think the siblings will ultimately get the estate, but it's just not over for now, which is really sad.
I'll just add, Paula, you started with this slide and mentioning that it was surprising that Prince didn't have a will, and I think the reason it was so surprising is he was notoriously protective of his image, his recordings, the fact that he had a vault of unreleased recordings, and there was a bunch of discussion about him basically giving control of that over to Jay-Z and Tidal and the issues that came out of that. And so it's surprising that someone who wasn't afraid of litigation, for instance, when it came to unauthorized use of his music or his image, wouldn't put something in place that would protect those very things if and when his time came.
Agreed. And I think that was for so many of us, the shock of it, because I agree with you. That was my next point. I know several of his attorneys, and so my thought was, why didn't y'all do something? So I'm still like that wasn't the case, and that's what makes it even more concerning for me. So we have 5 more minutes until we have to get the Q&A, but I think we probably can get 10. If need be, and then do 5 minutes of questions so we can get through. I want to make sure we hit Aretha Franklin, given that we decided that we were going to do this webinar today, because today is the day she's going to be put to rest. So we'll go through these slides and continue. Go ahead.
So this is just an example. I just wanted to lay this out so people can see what the law is in New York for who is entitled to inherit. So if you see all the way at the bottom, you have your first cousins. First cousins will only inherit if you have no aunts and uncles, no grandparents, right, paternal or maternal, no siblings, no parents, no spouse, no children. So again, that's why I said their cousins are at the bottom of the totem pole. But it's important for you to understand, what the law is in the state where you live or the state where you die, or even the state where an individual wants their will to be probated, because, all of this is going to come into play. Next slide.
Okay, so, oops. So today, we, like I mentioned just now, we decided that we were going to do the webinar today about this because so many of us are frustrated from a legal perspective of having so many people who we love, even from afar, and from their celebrity, to not have planned for their estate. And so, as many of you know, Aretha Franklin died on August 16th, and she was a Detroit resident, so Michigan law applies. She was divorced twice and left 4 adult sons. The sons, after her death, named a niece to be appointed as her personal representative. So this is actually not allegedly. She actually did ask to be paid in cash for all of her gigs. And there's one story that where she actually was paid and then put her purse on the stage at a recent her last where she performed last. I'm sorry. She did this again, and so there were some people talking about this yesterday on the radio and said that she was consistent about her money. So you know, laudably, she retained original ownership to her compositions, including the what we all know, think. And this last slide, I think, is extremely for me sad. Right, her business lawyer, who she's been with for 30 years, asked her to do an estate plan, and she refused. And so many of the folks who I know who are in the legal profession and from Detroit said, this is, she knew what she was doing. She did this on purpose. She knew that the stuff, her information and all of her estate would be going to her sons. But my thought is this: great, yes, we know it's going to go to them based on the law, but what happens if somebody challenges this estate? And so let's talk about that.
And not just what happens if someone challenges the estate, because right now the reports are that the sons are working together. They came together to file the petition to administer, open her estate. They agreed on having her niece serve as a personal representative rather than one of them. I think the interesting point, and part of why her business lawyer was probably pushing her, is the tax consequences. And so Anta mentioned in an earlier slide that for some estates, they're large enough where there are tax implications. And so for her, the reports are her estate's valued at $80 million. A good portion of that is going to be subject to taxes, and some of it could have been avoided if a trust had been created or certain estate planning techniques had been used to deal with the tax complications that will result from the administration of her estate. Also, the fact that now she's passed, her business lawyer or her lawyers may not be involved in whatever the process and plan is for post-death tax planning and estate planning, because her son and her niece are now in charge. And so they can choose any lawyers that they want, and those lawyers may not come up with the best plan because they don't have all of the information from 30 years of working with her. And then the last point, and this applies to many of the celebrities we've mentioned, such as Bob Marley and Tupac, is as a musician, you have content and your legacy that's going to live on forever. And so the likelihood, unlike if I died right now, my estate will close at some point. Hers is probably going to be open forever because of royalties. Often when celebrities die, their music sales actually increase because they get new fans who knew nothing about them until their death, or people reminiscing on their life go out and buy more of their music. So Tupac, for example, died with debt, actually. And so some people, as we saw in one of the polls, will say, I don't have enough assets in order to create an estate plan. But if you think about it and really sit down and focus on what your assets might be, while Tupac died with debt, he had unreleased music. In many ways, his death actually caused his celebrity to increase. And in using sophisticated post-death planning, his mother was actually able to grow his estate to $40 million in value. But that's something that he could have put in place from the beginning and dealt with the debt and creditors by creating a plan to deal with that. And so the importance is definitely there to consider these things while you're alive and can make the decisions yourself. Okay, so this slide just briefly establishes some of the reasons that you need a will. or the use of having a will. Naming an executor of your choosing, which we talked about before. That person at your death is responsible for collecting and valuing your assets, paying any debts, taxes, claims, fees, including attorney's fees and professional fees, and expenses related to the estate from money coming from the estate, as well as, if applicable, preparing estate and income tax returns for the estate, which evaluation needs to be done in order to determine what those numbers are, paying out legacies, which are the distributions to your beneficiaries, or if you have a will, the people you name as beneficiaries within that will. And then to move on, as we mentioned before, naming a guardian for minor children, providing a method to distribute property to minors, because, of course, minors can't just outright inherit or own property. Then using trust, which for Aretha Franklin, to bring it back, one of her sons apparently had special needs, and so that's a consideration that would have been great while she was alive, to take into account that as someone with special needs, maybe a special needs trust or another type of trust for differently abled people would have been needed. And then, of course, in a will, you can donate to charity as well as take tax efficiency and apportionment into consideration. Apportionment deals with where the taxes are paid out of from each beneficiary gift or from the estate as a whole. Anta, you want to handle this?
Sure. So as we started talking in the beginning, we talked about some of the reasons that people have not actually, completed their estate plan or even started in some cases. And there really are a lot of misconceptions about what estate planning is. We talked about the joint ownership of property, right? Some people usually think, well, I own it, so it's going to go in my will, it's going to be handled that way. But again, as Carl was discussing earlier, it depends on how you own the joint property, because if it is the type of ownership, that we call rights of survivorship, right, that basically means that once you die, the other owners of that property will be entitled to it, and it'll pass automatically to them. Right, and so there's a misconception about what it means to jointly own property and how it will pass when you die. Other things are, life insurance, retirement accounts, pensions. People think that it's going to resolve itself, right? But remember, all of these have beneficiary designations. So if you named your husband or your wife as the beneficiary of one of these accounts, and then you die and you are separated from that husband or wife, guess what? If you do not have a legal decree of divorce, they will still inherit, right? And so people don't understand that. So you need to look at your documents, confirm that the beneficiaries are the ones that you want, and change them if they aren't. Then other things are, about it, disinheriting people, right? You cannot disinherit your wife. Again, if there is no legal decree of divorce, right,
or husband,
that person will continue. Yes, or husband. If there's no legal decree, right, you are still married, they are still entitled to, your assets. Right. Now, you can't disinherit your spouse, but you can definitely disinherit your children, right? And for some people, that's something they want to do. So you need to consider that also. And then lastly, in terms of probate, it depends on, the nature of your assets and how much it is. But more recently, some more than others, the courts in New York, in the different counties, have really tried to make it more accessible, right? Make the probate process more accessible to individuals. There's a ton of forms online and instructions. We do get asked all the time, well, why can't I just do a lifetime or living trust and just leave it that way and, it'll handle itself? Not all the time. It really doesn't work all the time, and it could be more expensive, if anything. So, we and these are just a few of the issues that, we have faced in our practice about why people don't want to do estate planning or never get to it. There are a lot of misconceptions, and if you take anything away from this webinar at all, anyone 18 and over should have some sort of estate plan in place, period.
Okay, so there's several questions in the queue, so I'm going to start asking them to our panelists. The first is, does estate planning extend to properties in other countries as well? Please answer as concisely as you can.
Yes.
Sorry.
It's like so I do want to add that again, the same way that we talked about how different states vary, different different countries vary, obviously. So, but that's something that you can take into consideration when you're doing your estate plan.
And I think that would be a great topic for a future webinar too. Okay. The next question is: Do you need to leave a detailed list of your assets at the time you sign your will in the will? I assume everything goes to the spouse if you are married. Is it possible that the child of the marriage and spouse get equal shares if that's how you want it?
So it depends. So for the first part of the question, no, you definitely should not. I do not recommend that you list every single one of your assets in your will. And typically the way it works is it's sort of categorized. So we will say all of my tangible personal assets, right? Your clothes, your car, your shoes, you leave that to someone. Then your real property you leave to someone, and then all the rest and residue, everything else, bank accounts, securities, you will divide up however you want. In terms of spouse and children, it depends on where you live, but let's assume New York. In New York, if you do not have a will, the spouse will get, and I always forget this number, the spouse will get 50,000. Carl, you can correct me. I think the first 50,000. Okay, so the first 50,000 will go to the spouse, and then the rest will be divided half and half with the children and the spouse. Other states may be different, right? But in terms of if you leave a will and say 50-50 to my spouse and my children, it may or may not be sufficient, because one thing that we didn't get into here is what's called the right of election for a spouse. Because you can't disinherit your spouse, right? Your spouse can say, you know what, I don't want that 50%, because if I exercise my right of election, I may actually get more than just the 50%. So right. And that gets a little bit more complicated, because technically you could say they get 50% and you put it in a trust, and there's a whole bunch of other different mechanisms and things you have to think about in order to make sure that works. But it is possible. It gets into a lot more complicated estate planning tools. But you do have to be careful about that, because just because you say divide it between my spouse and children equally, it doesn't mean that's how it's actually going to work. And that's why we also wanted to emphasize here that even if you have a will, if it's not sufficient, the plan is not going to work.
Okay, so there are several other questions, and we promised, we already discussed this prior to getting on the call, that we're going to do another estate planning topic webinar. So never you worry if we don't get to your question, but I am going to close with one final question for the panelists, which is, how do you think and plan for your debt and creditors in your will?
Carl, you want to take that?
I mean, you have to assess your assets in comparison to your liabilities. And so a will typically say that, your executor is directed to pay your expenses. But one of the things I at least try to avoid when doing that is saying, for instance, my executor should off the top pay all just debt, because that may open the door to creditors who the statute of limitations is already run, saying you reopen the door to my claim. And so it's really a fact-specific question of identifying exactly what the debt is, and if it's something that you can address, of course, while alive, or create the plan for it. However, for instance, let's say you're talking about a mortgage on a home. Typically, the gift of the home will be subject to any debt or mortgage on the home, and so the person would be inheriting the house in addition to the mortgage if they so choose to accept that testamentary gift or gift from the will.
One thing I want to add, I'm sorry, I know we're running out of time, in terms of debts, I completely agree that you need to be able to identify while you are living what your debts will be and it's an annual thing. I mean, I think it's a monthly thing, something you need to keep an eye on. But one of the other misconceptions that I know people do not understand at all is about what happens to your debts when you die, right? Because let's say you die and you only have a spouse, right? Your spouse is not going to get any portion of your estate until all of the debts are paid. So that includes funeral expenses and arrangements, right? That comes off of the top. If you hired a lawyer to help with the estate, they have to get paid. If you hired an accountant, they have to get paid. Debts you identify, valid debts, have to get paid. If for some reason, after you pay all of that, there is literally zero in the account, there are no more assets, guess what? All the rest of the creditors, they will get nothing. You as the spouse will get nothing, but the creditors also will get nothing. And the most important part, you are not liable for those debts that will not get paid, okay? You as in spouse, children, cousins, any family members are not liable for those debts unless you were a co-signer or you somehow, were also, signed off on those debts. But if the debt was only in the decedent's name, right, they can only be paid to the extent that it's a valid debt, first of all, and also to the extent that the estate actually has assets to pay. And I've unfortunately seen these situations in mortgage situations where there has been a foreclosure or they were about to file foreclosure. And, I'm very biased. The banks are sleazy. And what they do is they will send out a notice to anyone that they think is a relative saying, this is about to go into foreclosure. Please call us so we can make arrangements, for you to pay the mortgage or get this out of foreclosure. And unfortunately, people call and they sign documents and now they're on the hook for the mortgage, right? Mm-hmm. And again, they weren't on the hook for it before. It's not their debt. And this is huge because, again, I think banks are sleazy and they know that you're not supposed to be on the hook for it, but they still send these things out and it makes people nervous. So I just wanted to throw that out there.
Right, and I'll just quickly add, because we're closing, that some creditors will, depending on the amount, they'll actually not even go after it. I've seen it where a small credit card, say $3,000, you inform them that the person has died, they end up writing it off because it ends up being cheaper for them to take the tax write-off than to file the litigation claim or the estate claim for the debt and go through the process of having their lawyers do that. So.
Okay, well, this has been a very informative and invigorating conversation. I hope that it was a catalyst for all of you who are the 25% who don't have an estate planning document, or the 75% who don't have sufficient estate planning documents, for you to be catalyzed in order to do something. I know that I am. And so on behalf of the Metropolitan Black Bar Association, Anta, Carl, and myself, who are all board members, we thank you for joining us. The content for this webinar will be circulated via our newsletter, and it will also be in our social media channels because we're going to post this on YouTube. So please do share it with your friends and colleagues. We hope that we'll be able to have other people understand the importance of planning for their demise, because we're all eventually going to get there someday. And as a closing, we want to remind and keep in our hearts the family of Aretha Franklin, who's burying her today. Thanks, everyone, and have a wonderful, wonderful day. Bye-bye.
Thank you,
everyone.